Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hi, everyone.
Hi, Dennis.
Hi.
Now, last Friday saw our Day 2 conference online, and many thanks to all the speakers and delegates for making it such a success. But we've got lots to get through today, Dennis, so let's make a start with the amazing news about remote meeting provision.
Well, indeed. Just as our spring conference delegates were getting together in Bristol, the government has confirmed that it plans to permit local authorities to develop their own locally appropriate policies if they decide to hold remote meetings. In its response to a consultation, the ministry also set out its stance on proxy voting, revealing that it plans to require principal councils to implement proxy voting schemes for meetings of full council. The ministry said it planned to legislate to support permanent provision in relation to both remote attendance and proxy voting when parliamentary time allows. Now, Helen, this is a major policy success for LLG that you were personally involved in.
Yeah, I mean, absolutely delighted, of course, Dennis. We started this back in 2020. I mean, that's some 5 years ago now. And that's once the sector, we realised the sunset clause would remove provision. I don't think that was immediately obvious to anybody, actually, that was going to be the consequence. And of course, we worked closely and directly with ADSO throughout that period, lobbying what was 8 different, we are on our 8th minister from that period. It's quite amazing. And of course, we brought the High Court case in 2021. We submitted freedom of information requests to the government to release that call for evidence way back. And we united with other stakeholders to place pressure to make provision. And of course, towards the end, when the Levelling Up bill was going through, we worked with NOUT to get support in the House of Lords. And, the sector really came together on this, Dennis. And I have to give, though, a special mention to John Austin from ADSO here, whom I worked directly with throughout the pandemic, often in the evenings and at the weekend. And the important thing here, Dennis, though, is that this provision is absolutely right for the sector.
Well, yes, certainly. And the consultation response said the government is of the view that in-person authority meetings remain vital for local democracy, but that hybrid and remote attendance and proxy voting will enable local authorities in England to develop more modern, accessible and flexible working practices. And the ministry said the proposed requirement for proxy voting schemes for meetings of full councils was to provide consistency for members who are absent when they become a new parent or for serious or long-term illness. For all meetings other than full council, proxy voting may be used but will not be required, and substitute or pairing schemes may be more appropriate, it added. And the consultation response went on. We plan for local authorities other than principal councils to be enabled but not required to implement proxy voting schemes for any of their meetings. The government added that it would collaborate with the sector to develop clear and supportive guidance in relation to both remote attendance and proxy voting policies.
Yeah, well, in December of last year, when LLG responded to the government's consultation, our position on proxy voting was as followed, and it really came out of, the survey with our membership. Most members, it has to be said, were opposed to it. And it was broadly felt that the substitute system already operated by most local authorities is more effective, frankly, and that authorities already have the power to send a replacement member, which maintains political balance without the risks associated with proxy voting. And I think the main sort of concern that was coming out was around the use, it was basically about how proxy voting would sit alongside the issue of predetermination. And some members felt that it was unclear how a failure to hear debate and therefore ensure an open mind could be adequately overcome. Particularly, I think, really the concern lies in the area of regulatory meetings. As a body capable of being judicially reviewed, obviously any kind of provision in this area needs to be seriously considered. LLG's position was that this could be addressed by the donor transferring their vote to the proxy, meaning that the proxy is accountable for how the vote is exercised. And, you know, arguably, provision, you know, would maintain the electoral balance and therefore mandate. I think it is worth noting it could reduce public confidence in effective representation by their councillor, demonstrated by over engagement. It might, and we've always got to think of unintended consequences here. It might encourage less participation in some meetings by councillors. I think that is worth thinking about. And there's this big grey area around councillor interests and declarations and how they'll be managed. You know, where information becomes apparent at the meeting in question that might not have been raised previously. And also, I think there needs to be quite a bit of thought around how motions from the floor would be handled, Dennis.
Yeah, I think there's a lot to work through there, but obviously we will keep members informed and up to date on all of these aspects and those particular issues that you've raised there. Now, back to the consultation. This received 5,844 responses. That's an enormous number, isn't it? A significant majority, 86%, of respondents were in favour of the broad principle of allowing remote attendance at council meetings, and only 16% of respondents thought that councils should not have the flexibility to meet fully remotely under any circumstances.
Well, I haven't checked the statistics from the previous call for evidence that the government launched at the same time as our High Court hearing in 2021. But I believe that figure, that 5,844 response figure, is actually higher. I know it was around the 5,000 previously, but it's great that the motivation and the passion from the sector remains so high, which really demonstrates the view that we need to have it. And you know, Dennis, I don't think local authority will be routinely having remote meetings. This is about flexibility, isn't it?
Indeed, it is. It's an option.
Yeah, exactly. But we'll continue to work with the government to help inform the legislative provision moving forward and report back on the grapevine and other types of communication. Now, let's turn to other news. Something that anyone working in the field of antisocial behaviour some 20 years ago will be familiar with is the Vagrancy Act of 1824. And this is the news that the government has confirmed it will repeal the act by spring next year to ensure that rough sleeping is no longer a criminal offence. Now, the government's press release stated that the outdated Vagrancy Act 1824 will be axed for good. That's interesting. I thought the use of that word was interesting, reflecting modern attitudes, increased financial support for the homeless, and the government's mission to get to its root causes. New legislation will target real crimes instead, such as organised begging by gangs and trespassing, which the government says will protect communities without penalising vulnerable people.
Well, that's right. And after 200 years, then, rough sleeping will no longer be a crime. And interestingly, the Act was originally introduced in 1824, as you say, towards the end of the Georgian era. Can you imagine? To deal with rising homelessness, which increased after the Napoleonic Wars and the start of the Industrial Revolution. While use of the Act against rough sleeping has significantly declined, it does remain enforceable in law. The government will be repealing the Act to ensure that rough sleeping is no longer a criminal offence, as it concentrates its efforts on getting to the root cause of homelessness. The ministry says that it has boosted funding for homelessness services by an extra £233 million this financial year, bringing total investment to nearly £1 billion. And this support is intended to prevent more families from entering temporary accommodation and to tackle rough sleeping head on.
Well, I understand that the Deputy Prime Minister is also developing a new homelessness strategy with other government departments and mayors and councils who all play an important role in prevention and frontline support. And we can expect this strategy later this year. And in response to that news, Angela Rayner said, and I'll quote, "We're drawing a line under nearly 2 centuries of injustice towards some of the most vulnerable in society who deserve dignity and support." And I have to say, I completely agree with that. The Minister for Homelessness, Rashanara Ali, said that scrapping the Vagrancy Act for good is another step forward in our mission to tackle homelessness in all its forms by focusing our efforts on its root causes. Now, government amendments to the Home Office's crime and policing bill will focus on real crime and not rough sleeping, with no replacement of previous legislation that criminalised people for simply sleeping rough. Now let's move to other news in the form of regulatory inspections, Dennis.
Yes, and still on the subject of housing, as you know, we regularly post in the bulletin the various reports and inspections undertaken by regulators and organisations with oversight of local authorities, and not least in the area of housing. And we do this so that lessons can be shared among all local authorities. But what are those lessons? A useful article in the Local Government Lawyer focused on housing and the 35 local authorities whose consumer standards were examined and graded since the passing of the Social Housing Regulation Act 2023. So, what can we all learn? Local authority registered providers must ensure that they comply with all aspects of consumer standards. However, in the judgments the housing regulator has made so far, there are some common themes. And here we go. There are some reports of, indeed many reports of, a lack of evidence about the condition of properties, specifically a lack of stock condition survey data. Secondly, gaps in relation to health and safety compliance with numbers of outstanding gas or fire safety checks and lack of smoke or carbon monoxide alarms being particularly common. Third, there are significant backlogs of repairs with both high numbers of outstanding repairs and long delays in having those repairs carried out. Similarly, there are reports of backlogs for dealing with urgent repairs. Next, a number of homes have been found to be not meeting the decent home standard. Again, next, there's been a lack of proper processes in place to assess and mitigate the risk to tenants of living in homes where issues are outstanding. Next, there have been found to be failures to establish proper tenant engagement structures where tenants have meaningful opportunities to scrutinise and influence decisions taken on their behalf. And finally, the reports indicate that there are issues with the collection of tenant satisfaction measures survey data. Now, local authorities would be wise to review their internal operations, particularly in relation to all of these issues, to address any compliant questions with the consumer standards. Now, this will help to ensure that your local authority is best prepared for its own inspection and, more importantly, will ensure that your residents are receiving the service that they should and are living in a safe and decent home. Helen.
Yeah, well, that has to be the focus, Dennis, of course, doesn't it? Now, anything is achievable with the right support. This is the latest research by the Welsh Senate and taken from our Welsh Bulletin in respect of closing the disability employment gap in Wales. Capability isn't the issue, it's the lack of opportunity, it says. Now, the research states that employers, as we know, play a central role in closing the disability employment gap. The Equality Act 2010 requires employers to make reasonable adjustments to ensure disabled people are not unfairly disadvantaged in the workplace. Now, these adjustments can remove practical barriers, and many disabled people shared with the committee that was looking at this in Wales how such changes have positively impacted their working lives. However, the report found that in reality, many employers don't put in place these crucial adjustments. And the RNIB shared their research with the committee, which found that 23% of employers are not willing to make adaptations to employ someone with a visual impairment despite legal obligations. And the TUC has called on employers to review their policies on making reasonable adjustments, highlighting the results of their survey of 1,000 disabled workers, which found that 34% are not getting the reasonable adjustments they need.
Disability Confident is a UK government accreditation scheme which encourages employers to think differently about disability and to take action to improve how they recruit, retain and develop disabled people. Despite the potential benefits of the scheme, the committee heard that it lacks credibility among the disabled people who associate it with the Department for Work and Pensions and say that it lacks rigour. Now, the committee was concerned to learn of the relatively small proportion of public sector organisations in Wales attaining the highest level of accreditation, with only Pembrokeshire and Bridgend of the 22 local authorities and only 4 of the 12 NHS health boards and trusts having actually achieved this status.
Well, the Welsh Government has accepted the committee's recommendation to seek urgent changes to the Disability Confidence Scheme and has brought the committee's report to the attention of the UK Government. However, the UK Government's Green Paper on disability reform doesn't reference the scheme. Now, the Welsh Government has also only accepted in principle the committee's recommendation to require devolved public sector bodies to make a more substantial contribution to the aim of eliminating the gap, the employment gap. However, the draft Disabled People's Rights Plan states that the Welsh Government's commitment to increasing the number of employers in Wales achieving the highest accreditation, and that's referred to as a leader status. So the committee concluded that employment support can make a significant and positive contribution to closing the gap, and they called on educators, employers and governments to take concerted action to address the underlying causes of the employment gap and provide much needed employment support to those who can work. Now, let's move from disability discrimination to sex discrimination. Dennis.
Yes, listen to this. 6 in 10 women in law have experienced sex discrimination at work, while 7 in 10 stayed quiet about their experience, fearing that it would damage their careers. These are the worrying findings of a survey conducted by the Next 100 Years project. This year marks the 50th anniversary of the Sex Discrimination Act, which protected men and women from discrimination on the grounds of sex or marital status, covering employment, education and harassment. However, 88% of the 148 women who responded to the Next 100 Years survey said that sex discrimination remains prevalent in the legal profession. 8 in 10 women knew colleagues who experienced discrimination in the last 5 years. Half of respondents said that their organisation took alleged incidents seriously, but 1 in 5 said that their firms did not. Asked who was being discriminatory, a third of respondents pointed the finger towards leadership figures. Nearly 2/3 of women fear that their firms will deprioritise diversity and inclusion initiatives as a result of the US President Donald Trump's assault on DEI initiatives. And of course, pronouncements since the last local elections by the Reform Party to root out diversity jobs and roles suggest that there is political pressure for this deprioritising of DEI in our sector too.
Well, the Next 100 Years founder and solicitor, Dana Dennis-Smith, said, and I'll quote her, "It's alarming," and I agree, "to see so many women working in the legal profession still exposed to discriminatory behaviour, and that in many cases it appears to come from across the organisation, not just a few rogue individuals. Whilst it's good to see a majority of organisations taking this issue seriously, if women still feel speaking up could impact their career prospects or suspect their organisation's leadership to be complicit, we are a long way from seeing the change we need to help women thrive. There is clearly more to be done, and I hope that initiatives such as the Harman Review will go some way to addressing the issues women in law contend with."
Indeed. Concerned about the knock-on effect of what has been unfolding in the US, Dennis Smith, who becomes Law Society president in 2027, said that the legal profession must redouble its commitment to workplace equality and foster a culture where discrimination is not tolerated and that those who experience it are empowered to speak out.
Yeah, hear. And our final item today, taken from the local government lawyer, this is the news that the Supreme Court has refused a school permission to appeal a ruling that the dismissal of a Christian employee constituted unlawful discrimination on the ground of religion or belief. Now, this is a bit wordy, so bear with me. But in February this year, the Court of Appeal allowed an appeal from Christy Higgs, who was a pastoral administrator and work experience manager, who was dismissed in 2018, so some time ago now, by Farmers School because she posted messages on her personal Facebook account opposing the teaching in schools, and in particular primary schools, of gender fluidity, and also that same-sex marriage, she said, is equivalent, she took issue that same-sex marriage is equivalent to marriage between a man and a woman. So that was the reason for her dismissal. Now, the Employment Tribunal found that her beliefs, including against same-sex marriage and gender fluidity, were protected beliefs. However, this claim failed. The claimant was not dismissed because of her protected beliefs, it found, but because the language of the posts created a reasonable concern that she would be perceived as holding either homophobic or transphobic beliefs, which could in consequence affect the school's reputation. That's a very difficult situation, I think. So this went off to the Employment Appeal Tribunal, which allowed the claimant's appeal, and it said that the Employment Tribunal should have found that the posts were a manifestation of the claimant's protected beliefs. Dismissal because of the manifestation of beliefs itself would be discriminatory. However, dismissal because of an objectively objectionable feature of her manifestation of protected beliefs would be for a separable, non-discriminatory reason.
Well, the Court of Appeal allowed Higgs' appeal, finding that the school's dismissal of the claimant was not objectively justified. It was therefore due to this manifestation of belief itself, and therefore discriminatory. In the judgment, the Court of Appeal approved the Appeal Tribunal's application of the case of Page and the NHS Development Trust, and suggested that the jurisprudential basis for the decision of Page was based on 2 points. First, reading down the Equality Act 2010 under Section 3 of the Human Rights Act 1998, and or secondly, a highly purposive interpretation on normal statutory interpretation principles.
Well, the school had asked the Supreme Court to consider the following issue, and that was where an employee manifests a belief which is protected under the Equality Act in an objectively objectionable manner, is adverse treatment by their employer because of their protected belief, as opposed to the objectionable feature, and therefore direct discrimination, unless the employer can objectively justify that treatment. However, as stated, the Supreme Court refused permission. And it really is a case for the employment lawyers to have a really good look at and digest, because it kind of cuts through this thorny issue about protected beliefs to some extent. And on that note, that's it for another edition of the podcast. You can read more on the items discussed today and many more besides by going to bulletin number 22, available on the LLG website now. So goodbye from me.
And from me too. Bye now.